Hello everyone, I'm Andrea. I'm an assistant professor at Junior Global Law School, and I've titled my paper as The Meaning of Life under the Indian Constitution and the Obligation to Not Render Persons Stateless, with special reference to the National Register of Citizens. Before I begin, I would like to take this opportunity to thank all the organizers for putting this together because this has been very helpful. The inspiration for this paper actually came from two documents that I read. One is called What Would Life Be Like If You Had No Nationality by UNHCR, the UNHCR publication. And the other is a judgment from the Indian Supreme Court, Francis Immanuel versus Administrator, Union Territory of Delhi and others. So I found that the arguments that are made in the UNHCR publications of the effects, the harm that one faces without a nationality had some sort of linkage with the arguments that, or the points put forward by the Supreme Court in discussing right to life in the Francis Perelli case. I was guided in writing this paper by the research question, how the obligation of the state under Article 21 of the Indian Constitution should include the obligation to not render persons stateless. I have answered this question in 3 sections in the paper. Firstly, in first section, I addressed what is the meaning of the obligation to not render persons stateless and how this obligation applies to India. I then argue what is the meaning, I examine what is the meaning of life under the Indian Constitution and what is the relationship of life with this obligation to not render persons stateless. And finally, I apply the conclusions to the NRC updation exercise in the stamp. So firstly, to answer whether this obligation to not render person status applies to India and what exactly does this mean, I looked at Article 15 of the Universal Declaration of Human Rights, or UDHR, which says that there's a right to nationality, everyone has a right to nationality, and it says that no one should be deprived arbitrarily of their nationality. So from these 2 points, I argue that the obligation to not render person status can be interpreted, or its meaning can be analyzed from these 2 points. From looking at right to nationality, I found that nationality is more of a membership or a core right that is essential for a person to. Is it clear now?
Yeah, that's much better, Andrea. Thank you so much.
So from analyzing the right to nationality, I found that nationality is sort of the minimum right or the membership that a person needs to be part of a society and have access to the full range of human rights. While human rights by their nature are inalienable and applicable to anyone just on account of their humanity, what I found is that without nationality, a person is left in a state of legal limbo, and it's nationality which enables that person to enjoy human rights. Again, the prohibition of arbitrary deprivation of nationality mandates that whatever state action creates statelessness should fall within certain recognized exceptions under international law and should be proportional to should pass the test of proportionality, should have a legitimate state aim, and should be non-discriminatory. So based on this, I analyzed that the meaning of the obligation not to render person status is that states have a minimum obligation to make sure that no person in their territory is left without this basic minimum membership that enables them to enjoy other human rights. Then I move on to how this obligation is applicable to India. Firstly, this is because international law as a minimum requirement says that states are under an obligation to avoid statelessness. This has been said in treaties. This is part of treaties. This is arising from the right to nationality, which is part of human rights treaties as well as both international and regional. It has been affirmed by regional courts. It is also part of customary international law and general principles law. This has also been affirmed widely by scholars, and all of this applies to India because India is a party to some of these treaties which affirm the right to nationality, like the ICCPR and the Child Rights Convention. So based on this, I argue that this obligation applies to India also because this obligation is part of customary international law. Then I look at how this obligation applies as part of domestic law. And I found the Supreme Court has generally looked at international law when it comes to human rights matters in a couple of circumstances. One, when there is a lacuna in the domestic law, the Supreme Court and other high courts have referred to international law, or to interpret harmoniously domestic law with international law, especially in human rights matters, to reflect changes that happen in international law. The Supreme Court has applied directly international law treaties or customary international law obligations in its jurisprudence. So based on this, the obligation to not render persons stateless would apply. Firstly, because it's part of it arises from the right to nationality, which is part of the UDHR. The UDHR itself has been referred to by the Supreme Court to interpret human rights. Secondly, this would apply because there should be a harmonious interpretation of domestic law with international. After concluding that this obligation does apply to India, I move on to the examination of what is life, what is the meaning of life, which is what the paper's title is about. Life under Article 21 of the Constitution has been interpreted by the Supreme Court and other courts to include other rights, other basic human rights, and it's often called as a compendium of rights. So right to life includes the right to education, the right to human dignity, right to shelter, food, livelihood, right against detention, unlawful detention, right against solitary confinement, etc. And this is not an exhaustible right, and the Supreme Court has said that Article 21 is open to interpretation and more rights can be added. So looking at the right to life, is there any relationship with the right to nationality? Simply because if the right to nationality is the right to have rights, or is the minimum right which you need to enjoy human rights, then would it have any relation to Article 21, which guarantees the right to life, or the right to many other rights? So in this examination, I found that I argue this in two ways. Firstly, I say that Article 21, the right to nationality, is a sort of precursor or is an essential requirement for the enjoyment of all the rights that a person is entitled to under Article 21. So this would mean that without nationality or without citizenship, a person will not have adequate and effective access and the right to enjoy all the range of human rights that are mentioned in 21, and so nationality is important. Secondly, I argue that the Constitution can be interpreted, Article 21 itself can be interpreted, and it can be interpreted by international law, because there is no law relating to statelessness in India, and secondly, there is nothing contrary in Indian law to prevent the application of this obligation. So when Article 21 is interpreted in this way, it should include, life should include right to nationality to the extent that nobody should be left stateless. So the obligation to not render a person stateless will form part of the obligation of the state to not deprive someone of their life. After this analysis, I looked at procedure established by law, which is the exception clause where life can be violated as long as it falls under procedure established by law. The way the Supreme Court has interpreted this is that any law should satisfy the principles of justness, fairness, and reasonableness. The interpretations that the Supreme Court has given for these terms actually are proportionality, legitimate state aim, and that there should actually be a law in existence. These are pretty much the same as the principles that are present in international law before an action can be taken that could lead to statelessness. So I finally apply this to the NRC process. The NRC process is primarily based on documentation, and whether the process is before at the initial stage of inclusion, which is made by the authorities to the registers, or it is made at the stage of the FTs, the foreigners tribunals. They are based on documentation. But the rules 2003 rules, which mandate the NRC as well as the foreigners tribunal order and amendment, do not take into consideration the problems that people face in producing documents. The effect is that people are deprived of their right to life simply on the basis identification or the lack of it. So I find that statelessness is a potential risk that arises out of this. And when I apply procedure established by law, the purpose of this law is the identification of illegal immigrants. But this purpose cannot be achieved by asking or requiring people to submit documents. So there is no connection or linkage between the purpose and the object of the legislation and the state action that is proposed. So statelessness that could be created on the basis of the NRC does not satisfy procedure established by law and is therefore